Welcome. As Dean, I'm Dean Serwin again of Serwin Media Group. I am the IP and entertainment lawyer of the group. I've been giving this presentation. I tailored it to us because we got mostly musicians. So I love the name. It was given for me. Hands off, that's mine. Trademark Basics, how to protect your brand. Let's run through it. So I don't know how much any of you actually know about trademark. It's one of the three intellectual property rights. There's trademark, copyright, and patent. So trademark, which we're talking about here, it protects the source of a good or service, right? Patent is something that protects the idea behind it, like Matt's new printer. There's a bunch of patents involved with that. Copyright is protects the original artistic or literary work, the expression of an idea. So when you write a song, you copyright that song. When you make your band name, you trademark your band name. So I'd given an example there, but I want to stay on point. But the better mousetrap, you've all heard that expression, build a better mousetrap. You patent the mousetrap, you copyright your ads, you trademark your name and your logo. So trademark, service mark, what are these things? Trademark, as it says, is a word, phrase, symbol, design, color, sound, or combination of any of those that identifies the source of goods or services and distinguishes yours from those of your competitors. A service mark is just a trademark that's for a service. So we usually just say trademark or mark. So trademarks are very specific. There's actually 45 classes of goods and services. You don't just, I'm going to trademark Stranger Prince and it's trademarked. No, you have to pick which classes you're going to actually be in. So for a band, you probably want class 9, which is for scientific things. So actually your printer's probably in class 9, the brand of it. That's for the recordings. Class 41 is for the entertainment services. Class 25 for clothing, and maybe class 16 for stickers, printers, calendars, those kinds of things. So again, there's a lot of decisions to make there. So let's talk about what trademarks are and aren't. Trademarks are actually what's called a common law right. They're derived from English common law, and they apply. If you use a name, you own it. The thing is, you only own it in a very limited sense. You own it exactly how you've used it and exactly where you've used it. So if you are in Costa Mesa, you'd own it in Costa Mesa, maybe a little bit around Costa Mesa, but somebody in LA could be using that mark. So if you want to control it in all of California and in Wichita, Kansas too, you go for a federal trademark. It lets you stop other people. You can interfere with somebody else who comes after you and wants to use that mark. And by comes after, I mean in time, comes after in time. So that little TM symbol, that's something that people get confused about a lot. That little TM symbol just means I'm claiming I have trademark rights. Anyone can use it at any time. You don't have to file a trademark application, nothing. The little circle R, the registration, that means you've received a registration from the USPTO. And if you use that and you haven't, it's actually fraud against the federal government too. That's a bad thing. So registration, you file for your registrations at the United States Patent and Trademark Office. There is one United States Patent and Trademark Office. There are lots of people that will use those words and other combinations and try to convince you that they are them and take your money. That's another issue we can talk about if we ever file a trademark for you, all the people that are going to come after and try to pretend they're somebody important and you should give them money to do things. You don't. PTO is the only place, the USPTO. You can do searches there. They have an amazingly well-designed for a federal government thing website. But as I'll get to in a minute, you probably don't want to do it by yourself. So if there's common law rights, why register? Because you don't want to look like this young lady right here. You don't want to find out that you thought you had rights or that you were starting a business, you're getting really into it, you're developing things, you're making product, you're making packaging, only to find out that someone else already has your same name for kind of the same thing you're doing. You know, it's very problematic. So when should you consider? Before you open, after you're making money, when you become really famous? No, you want to do it as early as possible so that you don't look like the unhappy baby and find out that I picked a name and invested tens of thousands of dollars and years of my life into it, and I can't use it because somebody else is going to sue me. Can I register anything? No. Trademarks have certain rules. Again, they distinguish your goods and services from your competitors. So, and you get to stop other people who come after you in time and want to use that same name in that same way. So we got to have some ground rules so that everybody's playing on an even playing field. You can't be generic. You can't, register bandage, right? You can't use something that's merely descriptive. 30-second toast. I had a client who wanted to trademark 30-second toast for a toaster. Didn't work. The USPTO requires that there's some imagination that's necessitated by the potential customer to figure out what it is. So if it's orange juice for orange juice, that doesn't require any. And you can't do vulgar things. You can't, use swear words. And proper names, you have to get permission. You have to actually prove that you have permission of the person whose name that is. So Dean Serwin's Flibbity Gibbet, they'd have to get my permission. So what's the process? It takes a long ass time. 8 months from start to finish is blindingly fast. Kind of like this, it takes a long time. There's two kinds of applications. You can do it based, thank you, Kevin, for the courtesy grin. There's intent to use, meaning I haven't used it yet, but I think I'm going to. Why would you do that, right? You get that early filing date. Everybody who files after you, everybody who starts to use it after you, you have already told literally the world, I'm using this name or I'm using this logo or this slogan. No one else can use it for this thing. So you get to put the brakes on them. If you file based on intent to use, ITU we call it, you'll have to later file a statement of use or SOU to show that use. The other way to file is based on actual use, meaning you've already used it in commerce. Commerce means any way that can be regulated by Congress. So typically interstate or international. If you've got a website, you pretty much have covered it. Okay, so if you're basing it on actual use, or if you do an ITU, when you file your SOU, you're gonna have to do a couple of things. You're gonna have to tell them when you first used it, ever, when you first used it in commerce. Those can be different things. And then you're gonna have to submit a specimen that shows exactly how you're using it in connection with your goods or services. And people break down there a lot. So I've got my little examples here. Over on the left, you've got the Coca-Cola logo. That's a drawing. That's just, here's the mark, right? Then in the middle, you have, here's a printer proof of, yeah, it's gonna look like this. You can't do that. You have to do the one on the right, which is the actual Coca-Cola bottle with the logo on it. That's how you're using it in commerce. That's what the consumer is actually going to come across. Okay, so what happens next? The long and winding road. I love this picture. It takes 3 or 4 months after you file your application before they actually assign it to one of the hundreds of attorneys that work within the trademark office. There's about 6,000 applications filed every day. And then you might, if there's a design element to your application, they'll assign some codes. We don't need to really worry about that. It's hyper technical. You can't do anything about it anyway. The examining attorney is going to look at your application. They might decide that they think there's a problem. Those problems can be minor, like, we don't like the way you said this, we want you to say it differently. Or again, you used a person's name, or hey, this seems like it might be a translation from another language, because butterfly and farfalla will cancel each other out. They both are the same thing as far as the trademark office is concerned. The big refusals, and this is where the problem comes in, why you want to hire a lawyer and not do it yourself. Likelihood of confusion, or the merely generic or descriptive, they're going to just say, nope, we refuse. And then you have to appeal. That can be a pain in the butt. So if once you make it through that process, they publish 30 days, people get a chance to say, nope, I've already used that. I want to block that. If you make it past that in an ITU application, they'll say, okay, you've got a notice of allowance. You got 6 months to file a statement of use. You get up to 5 extensions of that. Just got to pay a fee. Otherwise, you're going to get your registration. So final thought, why use a lawyer? Like I said, when you file, there's a lot of moving parts. And if you don't do it right, they're going to come back at you and say, hey, you got to fix this. And if you don't know how to fix it, you're going to ignore it. You're going to lose your mark. It happens all the time. I've had it happen to a lot of people I know. So again, which one do you want to be? This baby or this baby? I'd like to be the blurry baby on the bottom. Thank you very much. Any questions? By the way, that was a lot of information that took me years to learn. Uh, Literally, ask me questions here, send me email questions. I'm very happy to answer them.